Come on.
Please, Lordship, I beg to mention item number 20, Lordship.
Item number?
20. I have informed to the other party also, Lordship.
Do you have objection?
No, Your Lordship.
Then, what to do?
After
Why?
2 weeks, Lordship.
2 weeks?
Lordship.
Yes.
First place, Lordship.
Yes.
Your Lordship, I beg to mention item number 28, Your Lordship. Your Lordship, in this matter, the
Yes. The what?
The counsel for the petitioner is on leave, Your Lordship. So if this matter...
For the petitioner?
No, I'm for the respondent, but...
Who's on leave?
Archa.
The way you mentioned on his behalf for the respondent?
So I don't know that, Your Lordship, I don't know that she's for 28 because I keep looking for them.
Yes.
Yes, Your Lordship is on leave.
2 weeks, yes, okay.
Much obliged.
Please, Your Lordship, I beg to mention item number 18, Your Lordship.
Akhilesh Prasad?
Yes, Your Lordship.
What's the matter about?
It is regarding, Your Lordship, the regularization of the teacher.
2 weeks,
18-19
yes.
similar connected matters.
18-19?
Yes, Your Lordship.
2 weeks, yes.
Much obliged.
Yes.
Wait, please, Your Lordship. Your Lordship, I beg to mention item number 17, Your Lordship.
Bangmai Mara.
Yes, Your Lordship. 2 weeks' time, Your Lordship.
No objection, Your Lordship.
Very cooperative councils you have, legal council, yes.
Similar prayer for 25 and 26, Your Lordship.
21?
25 and 26, Your Lordship.
25?
26, Your Lordship. I pray for 1 week time, Your Lordship, in this matter. The conducting council is having some personal difficulty, Your Lordship.
Who's appearing for the respondents?
For the statement.
What's the matter about? Land acquisition? 26. 1 week, okay. Yes.
And similar prayer for item number 30 also, Your Lordship.
Then the
Here
list
I am
is
for the
gone.
respondent number 5, Your Lordship.
Who's for the petitioner? No objection? Very good. 2
The
weeks.
status will
3 weeks time.
3 weeks?
Yes, sir.
2 weeks only.
Highly obliged, Your Lordship.
Lordship, I beg to mention item number 15, Lordship, for 2 weeks' time.
On Mr. Nokhla's behalf?
Yes, sir.
No objections, my lord.
Okay, 2 weeks.
Right.
That's it.
Please, Your Lordship. Lordship, I beg to mention item number 31.
All the list is gone.
On behalf of the petitioner, Your Lordship. The conducted council is out of station.
31?
31.
Where's Mr. Sheikh?
He's out of station, Your Lordship.
2 weeks. That's it. Unending.
May I please, Your Lordship? I beg to mention item number 14, Your Lordship. 14. I've informed the other council.
14 for hearing?
Yes, Your Lordship.
Lordship, I'm appearing for respondent number 7.
You have objection?
No objection, Lordship. Already informed.
2 weeks, okay.
I'll object.
Your Lordship, I beg to mention item 23 and 24, which is connected matter, Your Lordship.
2024? Regular feed products.
My Lord, I have objection, my Lord. Let the matter come, my Lord.
Where's Dr. Mozika?
Your Lordship is on legs before the division.
Let it come up. Are you there in the matter also? Yes.
Lordship, I beg to mention
Enough,
item
huh?
number
What?
21. 21, Lordship.
Where's the Changreso?
You have some difficulty, Lordship. I'm going to consider
3 weeks, yes.
1 week, Lordship.
21
3 weeks.
And 27 also, Lordship.
Connected, Your Lordship.
27? 3 weeks, yes. I'll give you ample time, yes. So you won't have to mention again after 1 week.
Your Lordship, I beg to mention item number 29.
29?
Yes.
On whose behalf? Mr. Kinjing?
Yes.
Where's Mr. Kinjing? You've exhausted the list. 3 weeks. Yes.
Main list item number 1.
Lord, I retired in February 2023, my Lord. And my Lord, by this petition, I'm seeking for notional promotion, my Lord, with effect from the date when the DPC sat in August 2018. And in that particular DPC, my Lord, because in the absence of rules,
When did you retire?
February 2023, my Lord. Now, in the DPC that sat in August 2018, my Lord, now with respect to all the posts that were there for promotion, considered for promotion, separate yardstick was...
What do you mean several yardsticks?
Separate in a sense, my Lord, for the posts of director, DMR, the reason for not considering me recorded is that the service rules have not yet been approved. However, for the remaining posts, my Lord, they have been considered and...
As per the draft service rules?
Yes, my Lord. So, different yardstick. Thereafter, my Lord, since I was holding charge as director, I did not protest much, my Lord. I made a representation, my Lord. Fortunately for me, the representation was sent to the person.
You were serving as director? You were
as in charge.
Yes.
As in charge. Now, my Lord, at that
From
point
18
in time,
itself?
2018 itself, my Lord.
Till you retired?
I retired recently as joint director, my Lord. Now, what happened, my Lord, during that period of time, why I was victimized? Because, my Lord, in the post of as in charge director, my Lord, I was directed not to question the source of coal, my Lord, for which challans were being issued. Now, my fault was, my Lord, that I did not obey the demands of the political bosses, my Lord. So, therefore, my Lord, I was victimized. Now, thereafter, my Lord, they have...
Where have you said that?
I've made averments, my Lord, in my petition.
Para 27, Your Lordship, that is statement is really unfortunate, Your Lordship.
Now, besides that, my Lord, now on law, my Lord. On law, my Lord, 2018 August, DPC sits, my Lord, different yardstick. In my case, the rules are at the draft stage. The other posts were all considered, my Lord. Now, thereafter, my Lord, DPC was never held. DPC was never held, and before retirement, I make a representation. Fortunately for me, my Lord, my representation was forwarded to the personal department, my Lord. And recently, after retirement, my Lord, at page 20, my Lord, at page 57, I'm sorry, my Lord, Alexa 20. This was issued by the Personal and AR Department, my Lord, to the Department of Mining and Geology. It reads, my Lord, in inviting to reference to your, this is dated, my Lord, 24th of May 2023, after my retirement. It reads, my Lord, inviting to a reference to your letter above, I'm directed to inform you that the draft rules of the Meghalaya Ministerial Service have already been approved from our end, white endorsement dated 15/2/2019. So way back in 2019, my Lord, before I retired. So there's a clear case, my Lord.
I mean, this is Your Lordship. Lordship, can you have a look at para 27, Your Lordship? This statement, Your Lordship, in my humble and respectful submission, Your Lordship, is not in a good taste, Your Lordship. The writ petitioner, if he could have been in service, he would not have dared to make this kind of statement, Your Lordship, before this honorable court. Then another aspect, Your Lordship, in 2018, if you say that he's entitled from 2018, now we are in 23, Your Lordship. Why 5 years? There is a delay.
No, that he'll have to meet. That will have to meet. Why he hasn't come in 18 itself? Yeah. But why he should have filed a petition then only?
I pray for notice.
Yes, heard Mr. Philaman Nanguri, the council petitioner. If you notice, Mr. N.D. Shulai,
for all Your Lordship,
PAG with so-and-so, is present except notice on behalf of all the respondents. This matter after 4 weeks for...
Apply, Your Lordship.
Item number 2.
Please, Your Lordship. Your Lordship, in this matter, the petitioner is the wife of late Shri Raju Dom. Shri Raju Dom, during his lifetime, served as a Safaiwala. Your Lordship, can you hear me?
Yes, yes.
He served as a Safaiwala at Station Cell, Shillong 99, care of 99 APO. Now, Your Lordship, their marriage was solemnized on the 14th of March 1996, after which they resided in Assam Rifles Bazaar, Happy Valley, Shillong. Now, Your Lordship, in the year 2012, on the 6th of January 2012, the petitioner's husband, that is Raju Dom, he expired. After expiring, Your Lordship, the wife has tried to claim his debts and securities against his services. But Your Lordship, the respondents so far have failed to furnish the same onto her. Two representations, Your Lordship, dated the 1st of December 2022 and the 6th of April 2023 were addressed to the commandment of Station Cell, whereby they were asked to furnish the statements of debts and liabilities against the services of a deceased husband, so as to enable her to furnish a succession certificate from the competent authority. Now, Your Lordship, in this petition, a very limited prayer is the issuance of a notice to the respondents to furnish the statements of debts and liabilities.
Your Lordship will take instructions on this.
Yeah, we have all respondents.
All respondents.
Yes, heard Ms. D. Mauri in a conflict petitioner, issue notice. Ms. S. Rumthau, Vice Dr. N. Wazikar, DGSI is present, except on behalf of all the respondents. This now for 3 weeks for instruction stroke affidavit.
Item number 3.
My Lord, the listener herein, my Lord, is challenging the termination order, my Lord, dated 17 May 2023. That is at last page, my Lord. 38.
Yes.
My Lord, the petitioner, my Lord, he has been working as assistant teacher at Umsamat Presbyterian LP School, my Lord, since the year 1995. Now, prior to this case also, my Lord, there were 2 other cases, my Lord, which the petitioner had filed before this honorable court. What had happened, my Lord, there was some complaint against him, and thereafter, my Lord, on the basis of the complaint, the salary of the petitioner was withheld, and therefore, my Lord, at that time, to release the salary, my Lord, he came before this honorable court by WPC 104 of 2017. And in that case, my Lord, the honorable court was pleased to give direction to the respondents to release his salary. Thereafter, again, my Lord, one show cause notice was given on 28th September 2018, and thereafter he challenged that show cause notice White WPC 52 of 2019, and in that case also, my Lord, that case was disposed of with a direction that in case they want to conduct any inquiry, then there should be an opportunity which has to be given to the petitioner, and also all the statement of allegation and all this, the show cause also has to be precisely on that point. Now here, as far as this case is concerned, my Lord, only inquiry was conducted, and my Lord, without...
You took part in inquiry?
My Lord, I received a notice.
You took part in inquiry on what? Were you given adequate opportunity to present your case?
Yes, I did take part in the... Now, my Lord, there's... Without any disciplinary proceeding, my Lord, initiated against me, they have terminated my service, my Lord. That is my only...
Where was the inquiry report? You're given an inquiry report. What does the inquiry recommend? Conclusion?
There was no recommendation, my Lord. Conclusion, my Lord.
No, where's the inquiry report?
My Lord, may kindly come to page number...
What is page 35?
37 is the operating part. Conclusion.
So you're quite a character, that means. See the conclusion?
Yes, my Lord. At least there has to be a disciplinary proceeding initiated against me, my Lord.
Inquiry is already done. What is that? Isn't that a disciplinary proceeding?
And my Lord,
you said that you've been given adequate opportunity. Correct. We can't expect schools to maintain high standards like in discipline units. Something. The thing is that now, if there was some sort of proceeding, you were given show cause, you replied, and then.
Now, my Lord, there has to be some rules, laws under which my service can be terminated. There is nowhere.
No, where's the approval for termination?
I have violated, my Lord.
Where is your approval by the government for termination?
No, my Lord, that is not there. I have not received.
Yes, Mr. Harmi. Strange case.
Yes. I'll get instruction.
Notice has to go, my Lord.
Mr. Counsel Petitioner, issue notice, Mr. Harmi. Additional senior advocate.
Respondent 1 and 2.
Accept notice on behalf of number 2. Petitioner takes step for service of notice on the other respondents in 3 days. Just after 4 weeks. For instruction affidavit, yes.
Item number 4.
Please, Your Lordship.
Don't tell me that senior counsel is not feeling well.
Your Lordship, he's currently out of station, Your Lordship. So, Your Lordship, if this matter can come up after 2 weeks, Your Lordship. Lordship,
Last, you know what was the last request last time?
yes, Your
What
Lordship,
was the last
for the
request?
copies, Your Lordship. We've received the copies, Your Lordship.
This is, you can't run court this way. Can't do anything. Where's Mr. Changrai? So
he's available. He's in his chamber.
don't say that he's in chamber. Don't say that. The High Court takes preeminence over everything else.
He's having some personal difficulties, Your Lordship.
Parties pray the matter be adjourned. Just as matter after 2 weeks.
Much obliged, Lordship.
Item number 6.
May I please, Your Lordship? Your Lordship, I'm instructed to take adjournment on behalf of Mr. S. Markpan, who's appearing for respondent number 1. So he has asked to take adjournment on. Let this matter come after 1 week.
Where's the objection to condemnation?
Your Lordship, the objection is ready, Your Lordship. We're just waiting for our client to come and give his signature.
Whatever's ready is not filed, that's all.
Yes, Your Lordship. Your Lordship, we pray for 3 weeks.
3 weeks?
3 weeks.
Out of the question. For one, you're not filing any objection.
Lordship, I'm not in the record, yes.
You're not filing.
I do, Lordship, actually, I'm not in the record. So, Mr. S. Markpan, who's appearing for
Who's
respondent
appearing?
one.
Mr. Nath, you find out why you haven't filed objection? Respondent number 3, you haven't filed objection? MSD Maori for number 2, HR Nath for number 3, Priyanat for the 1 week's time file objection. Just thereafter. Yes.
Item 7.
Please, Your Lordship.
Who's appearing number 7?
State of Meghalaya, Lordship.
Yes. What do you have to say?
Lordship, actually, I'll have to seek instructions, Lordship, because
You seek it immediately because this is a matter of lot of public importance. And even the petitioners, they've been kind enough to say, okay, fine, let's see what proposal comes out. They will, they will examine it whether relocation of the retail outlet. Correct, Lordship.
My Lord.
Tom Mozika, anything to add?
Well, for us, there is the urgency, my Lord.
That's what agency. That's why you within 1 week you obtain instructions. 10 days. Yes, MS NG Shilla, senior advocate, has entered the parents' behalf of 107 today. She pays funds allowed 10 days time to obtain instructions just after 10 days. We'll try to close the matter, in a amicable fashion so that, you also don't suffer and the public interest doesn't suffer. Lordship. Yeah, keep that in mind. Lordship. Okay.
Item number 8.
How many times did you file affidavit?
Number of times.
How many? Since?
6 times it.
Lordship, actually, affidavit is almost ready. Lordship, I'm paying for 2 more days.
What about the affidavit file?
File, Your Lordship.
Right from Mr. Kriam. Mr. Kriam, correct? From last year, you've been very consistent in asking for time.
Actually,
This consistency should be shown, in the positive way, not in a negative way of seeking time.
Lordship, most of the documents are in Garo.
This is the same excuse we've made since February. Now it's in Garo language. Chinese, you've got to translate it also, by now.
2 more days.
2
more days.
2 more days. 2 days. Mr. S. Kiriam is allowed last opportunity on behalf of the file affidavit just after 1 week. We file it. Why you want cost?
No, that's
Then You're
9.
looking very, in.
My senior Mr. Paul has reached from Delhi. He's stuck in traffic. Kindly have it at the bottom of the board.
End of the board. Like waiting for Rockstar, huh? He's landed, you wait. Mr. Sen, you stand on the road with a banner.
10.
May I please, Lordship?
Yes.
My Lord, I am for the petitioner in item number 10, my Lord. I have received a copy of the affidavit in opposition. So this matter may be
Number 5, who's going to number 5? Yes? Yes, okay. Yes, Mr. Kumar.
My Lord, the rejoinder is not necessary, my Lord, so this matter may be posted for hearing, my Lord, after 2 weeks, madam.
Is it fight over pension or something? Why are you implementing for number 5? Who are you? I'm the wife. Okay. Mr. V. Kumar submits that no rejoinder is necessary to the affidavit file. This is a matter for hearing revision clause, and so on. So, yes.
11.
Give
Item 11.
Please, Lodge.
Affidavit.
Filed.
When was it filed? 7th.
Yes, Lordship.
The rejoinder necessary? No.
Your Lordship, we forwarded to the management committee. If necessary, can you allow us, Your Lordship, to file rejoinder?
After 2 weeks, we'll have it. Office note indicates that affidavit has been filed. Prayer has been on behalf of the also the petitioner for 2 weeks for rejoinder. Accordingly, for 2 weeks' time for rejoinder. This matter after 2 weeks.
12.
Please, Your Lordship.
Legally matter?
Legally.
Yes.
The Lordship state as a formal party, Your Lordship.
Where's the money? You've given them?
Oh, Your Lordship, please, Your Lordship. Lordship, like representation is still under active consideration. We're just waiting for the report, Your Lordship.
There's a scheme, correct?
Yes, Your Lordship.
Then he was working in the MECL.
No, my Lord. He was a private contractor, laborer, working on somebody else's site. High tension wire fell on him and he was electrocuted.
Where's MS Colney?
Lordship, Mr. H. Karwanlang is servicing.
Where's the H. Karwanlang?
He's having a matter.
What's your name?
G.N. Rinja.
See, 17.4, the order was made that representation be done, and it says that immediately it may be permissible. So, Mr. J. Renja today submits that the representation that have been filed pursuant to the order dated 17/4/2023 passed by this court is still under active consideration. Stop. This court notes that the factum of the incident which had occurred to execution is not in dispute, as also the fact that there is a prevalent scheme with regard to immediate ex gratia payment to victims of such tragedies.
Lordship,
Yes?
I beg to jump
Yes?
in. That scheme, my Lord, may not be applicable. My Lord.
It's not under workman's compensation, no.
No, my Lord. That scheme actually was implemented in 2020. Scheme very specifically says that this scheme will apply to accidents that occur after 2020. Accident in this case was in 2018, my Lord.
18?
18.
Okay.
So in our representation also, we had said that there is a scheme we know, but that will not apply.
No, and also that for such accidents, compensation is to be awarded appropriately. Stop. Next part, the respondent corporation is directed to decide on, or this is something. This one decide to dispose of representation and accord appropriate compensation within 4 weeks from today. Yes. Just a matter of the 4 weeks. Immediately after 4 weeks is
published.
13. 13.
May it please your lordship, I pray for some more time, lordship, to file the affidavit.
how many times you sought?
One time, lordship.
Further 2 weeks time granted to the state response file just thereafter.
Much obliged, lordship.
Hearing, item 16.
I'm not saying yes. I'm not saying.
May I please, Lordship. Lordship, the matter pending before the division bench has been disposed
over,
of.
Right?
Over, Lordship. But however, this aspect has not been touched by the
What
honorable
aspect
division
has
bench.
not been
Here, basically, but Lordship, the certain rules were not followed while disposing of the seized cattle, Lordship. So this aspect.
Let's see the judgment or division bench. I have not seen that.
You have a copy with you? No, sir.
Well, judgment.
I'm sorry, Lordship.
You mean to tell me that you haven't come prepared at the judgment?
Yes, sorry, Lordship. I'm just praying for some time, Lordship, because this matter needs to be heard. So I'm sorry, Lordship. My apologies, Lordship.
Mr. S. Panti for the petitioner submits a duty inadvertence. The judgment passed the division bench, which has a bearing in the matter, is not available with him today. Stop. He prays for and allowed 1 week's time. This thereafter and so on. So you should have brought it at least. You owed a little courtesy to the court.
I'm extremely sorry, Lordship. My deep apologies.
22.
Lord, if this matters.
Hey, 1 second. Kata judgment you upload this ni upload judgment to public specification na. Mana? No kami pada apa nak penyapun. Okay. I mean it's okay. Upload. Yeah.
Lord, this matter, if it's kindly taken after 2 weeks. I have not gone through the file also.
You can go through now. Aram se. What's the matter about?
Well, this is concerning school, madam.
Aram, you ready?
Next day we'll finish it.
Why are you looking so helpless?
This is with regard to the release of the salary, Your Lordship.
Why? You're ready to the matter?
Otherwise, basically we have already released the salary. There's nothing much to be argued. But since my learner friend, he wants time, so I have no objection. Next date we'll finish it, my Lord.
Since when has salary been stopped?
My Lord, the salary, the previous salary is not released, of course, but the current ones have been released. Next week or end week thereafter.
He said non-disbursed salaries of petitioners until date. Absent management committee said popular government. Is there a management committee in place now?
No, Lord. It's not there.
What kind of school is this?
It's an SSA school.
And what kind of school is this? A management committee? Who's Abdul Samad Sheikh? Is he here as a private respondent?
No, he's never appeared. And
he's gone
the case has gone,
against him?
yes.
Against all the other?
Against the private respondent, my Lord.
Only one?
Yes. Main grievances against this person.
These matters should just be disposed of.
We'll finish it on next date.
Next date is very convenient to see. Next date will have loaded, like today is the best time to do hearings. It's Monday and there's lots of time. You were the headmaster before?
Yes. Now I'm holding that post again.
So why aggrieved?
Lord, because, Lord, firstly the salary.
For how many months?
That is for almost. Lord,
so you were kicked out from the school after another person became headmaster?
Lord, what happened is that this person illegally found a managing committee and he became the headmaster.
Then what happened?
And then, my lord, against that we had earlier approached the Honorable Court. This earlier round of litigation, then there was a dispute with regard to how much scale the private respondent is entitled, whether he is a sanctioned teacher or not. So the government has said, my lord, that he is not a sanctioned teacher. However, in the course of the time, the whole disbursement of salary was undertaken by the private respondent. And in that process, my lord, he has misused a lot of funds. I have not got a single amount of salary for almost a period of 2 years.
Then he's liable for that. Have you filed FIR against his misuse of the funds?
But FIR, I'm not.
What will state respondents do? If the money, sanctioned amounts come to the school and the money is defalcated by the whatever secretary managing committee at that point of time, what will the government do?
Well, that is why we approach this Honorable Court for a direction, my lord, that whatever money is misutilized, that should be refunded back, and whatever salary that I am due to receive, there should be a direction that the salary should be given.
Very simple to say that, but then like where, how would you recover that money? As the counsel for the petitioner is having some personal difficulty, this is matter after 2 weeks.
Item 23.
My lord, this is my lord
Dr. Todi, one thing is this number 5 a very is he necessary respondent? Number 5, number 5. Number 5, is it a very necessary party? Number 5.
Net fee, my lord, in fact, they are the, my lord, they don't have a role because they are simply dispersing officer. Their role is central government, and my lord, this transfers from the scheme as well as their affidavit as well. Their role is simply whatever the money the central government give at their disposal, they are to disburse. That's all.
Dr. Mosga, ready in the matter?
And my lord,
state is also party, net fee is also party, my lord.
State is a pro forma party. State has no role at all, my lord. My lord, I will come to the affidavit, my lord, and my lord, the only lordship will kindly see.
No, only Meghalaya is not pro forma, it's a regular party.
State, my lord, in fact, like only, my lord, obstacle created by the central, my lord. Central, my lord, how the obstacle is created, second round of litigation, this one. Central also, because even earlier litigation, my lord, whatever the Honorable High Court, my lord, has passed the order, they again twisted that, my lord. So, my lord, I will come to, my lord, let me, my lord, just begin the case, my lord. If your lordship feels that, my lord, yes, my lord, that let the matter be part heard, let them, my lord, let them make their submission.
It's transport subsidy.
Transport subsidy, my lord.
To do the notification.
And my lord, this case is, my lord, lingering since 2014, my lord. 2014, my lord.
No, it's for which period is this transport subsidy?
Transport, this period is, my lord, 1/10/08 to 31/3/09.
1/10/08.
Yes, my lord.
That means October to March only.
Yes, my lord.
And what is the volume of transport?
No, my
what
lord.
is your claim? Sorry.
My lord, so far earlier part is concerned, my lord, it is disbursed.
No, I mean for that period, how much the amount? What's your claim?
Amount, my lord, amount is approximately, my lord, whatever not paid, it will be around 1 crore, my lord, less than 1 crore. This is the amount. But my lord, only the issue is to be seen. How the thing has been so casually dealt with, my lord, sees two things are there, my lord. Two things are there. So far the scheme is concerned, my lord. Scheme is, my lord, inbuilt mechanism is there, scheme, and my lord, they are to act in person as per the scheme. Of course, my lord, nobody will act beyond the scheme. Now here is the case, my lord. The executive authority, my lord, they apply their own mind, and the, my lord, I will, my lord, show the affidavit. It's a political statement they have given. My lord, this reminds me, my lord, of course, two theory, my lord. My lord, which, my lord, if your lordship permits me, my lord, I can say, my lord.
Yes, please.
My lord, what is the theory, my lord? In fact, my lord, this reminds me, my lord, that in Kauti's Arthashastra, my lord, Arthashastra, my lord, what we had the occasion to look into, my lord. My lord, in 300 must be 323 BC before Christ, my lord. You can get it re-audited if you have any doubt. That liberty was granted to central government. Again, my lord, what they did, Again, they again come to the same issue again, that cash payment was not that, this is like this. So this is, my lord, in nutshell the cases. So now, my lord, because of Markham Textiles, my lord, Supreme Court judgments are there, where my lord, Supreme Court said when the, my lord, the schemes are floated, this benevolent public purpose is to be achieved with that aim in mind, the schemes are floated. So, my lord, these are to be looked into true spirit and should not be denied. And my lord, but here is the case, and my lord, one should not sit over the issues. But here is the case, my lord, for last more than 10 years, my lord, they are sitting over the matter, illegally withholding the, my lord, transport subsidy. So where it is permissible, my lord. This is the, in nutshell, the case. So, my lord, I am coming to the issue, my lord, now.
Yes.
Lordship may kindly turn to page 24 of the petition, my lord. Page 24 of the WPC, my lord, 345.
There are two repetitions.
But two repetitions, my lord, for two periods. Earlier, my lord, two repetitions filed, but High Court, my lord, disposed of by common judgment. But my lord, again, my lord, since the issue has to be.
Yes, okay. 34 and actually 3.
My lord.
Yes.
So, my lord, so for the WPC 345 of 2021 is concerned.
345 first. The facts are similar. Everything similar.
Yes, my lord.
Yes, one.
Yes, my lord. Yes, my lord.
Yes.
And my lord, my job becomes easier because lordship has dealt with similar cases, number of similar cases, my lord. So my lord, my case becomes only, my lord, I come to the facts as well as, my lord, what the judgment is.
One similar case I dealt as a counsel was a very alarming case.
My lord, still, my lord, the lordship knows, my lord.
Alarming case in the sense that there was a supplier from Birmingham, you know, and the consumer was in Bombay, some copper ingots, and there was some dispute between them, got to payments.
My lord.
And what surfaced out from the truth is that there was never any transport from Birmingham to Bombay. The unit was in Ankleshwar in Gujarat. And these people, the consumers, our clients, had to pick up the matter. They had to pick up from Gujarat only ingots, brought it to Bombay for making these copper utensils and all. So you can imagine everything was a paper trail from Birmingham. And when they came for inspection, they didn't have power even to light one light bulb there. See, that is why you understand the difficulty of the central government in the sense that these things happen. So you think Artha Shastra, yes, evaders like that were there. So that was not a transport subsidy case, but it was a case of commercial dispute. But even then, this is what happens.
My lord, hard reality, lordship is also evaded, my lord, even when not excise matter everywhere, my lord, number of, my lord, persons, my lord. They are taking.
Dr. Tori, I am not.
My lord, but my case differs from party to party.
Of course.
Party to party. My lord,
Yes.
it can be generalized.
Yes.
Can be generalized, my lord.
Come to the next channel.
My lordship got it, my lord, page 24. Lordship has come to page 24, my lord.
This is dated.
So, my lord, see, so far this is a scheme, my lord. In fact, my lord, so far the lordship may kindly come to page 25, Roman 4. So this is not disputed, but only, my lord,
Roman 5.
Yes, my lord, it is not disputed, but still, my lord, I am just bringing it to notice of the Honorable Court. My lord, Roman 4. In case of northeastern region comprising of states of Assam, Meghalaya, Nagaland, Manipur, Tripura, and Union Territories of Arunachal Pradesh and Mizoram, the transport subsidy will be given to on transport cost between Siliguri and the location of the industrial unit in these states. While calculating the transport cost of raw materials, the cost of movement by rail from Siliguri to rail station nearest to the location of the industrial unit, and thereafter the cost of movement by road to the location of industrial unit will be taken into account. Similarly, while calculating the transport cost, finished goods, the cost of movement by road from the location of industrial unit to the nearest railway station, and thereafter the cost of movement by rail to Siliguri will be taken into account. This is the, my lord, in fact, the scheme in brief. Then lordship may kindly come to Roman 7. Freight charges for movement by road /sea will be determined on the basis of transport fixed by the central government, state government, administration concerned from time to time, actual freight paid, whichever is less. My, this is the scheme. Lordship may kindly turn to next page, my lord. All industrial unit located in the selected areas will be eligible for transport subsidy equivalent to 50% of transport cost of both raw materials as well as finished goods. Next, my lord, Roman 12. The state government, Union Territory will set up a committee consisting of a director of industries. But this is the constitution of the committee, my lord. Director of industries, a representative each of the state industries department and the finance department, industry department, finance department, which a representative of the Ministry of Industrial Department, Development is also be nominated. Central government also nominate one person, my lord. The committee will operate at the state of the Union Territory level and scrutinize and settle all claims of transport subsidy arising in state Union Territory. So, my lord, in fact, my lord, this is the state level committee, my lord. So, this is a high level.
The state level committees passed your bills.
Passed, my lord.
Claim, I mean.
Yes, my lord. Then after
Where
this,
is that?
Scrutinize, my lord. I am coming to that, my lord. Then, my lord, what happened? Then Lordship may can again come to Roman 16, my lord, down below. In the same page, page 26, my lord, down below. Directorate of Industries of the state and Union Territories concerned will draw up a procedure and arrangement not only for scrutinizing the claims of transport subsidy, but also arrange for prompt payment of the claims. Yes. So, my lord, for 10 years, my lord, this is a prompt payment, my lord, 12 years.
Yes.
Then, my lord, next page, my lord, Roman 16. The Ministry of Industrial Development will continuously review the arrangement made by the Director of Industries of the concerned states, Union Territories, and suggest modification in the procedure for scrutinizing the claim, payment of transport subsidy, etc. In fact, my lord, it is under constant supervision by the central government. They can review, and but fact remains, my lord. So far, the same procedure continues, my lord, because they have not suggested otherwise. Then, my lord, else what was there, my lord? After the SLC.
Now, what happened? You said earlier when you submitted, you said that after the scheme had come out, there was an alteration to the scheme.
My lord.
There was an alteration. What was the alteration then?
No.
There was a modification under the scheme.
The modification only, my lord, to that, my lord, they said that audit. Central government will make audit again. Suppose SLC improved, state level committees improved. Yeah. Thereafter, that is not the end of the matter. But there has to be audit by the central government, audit team.
Yes.
Audit team or not state audit team, but central audit team. They come, they audit it. After they audit, then the matters, my lord, audit become final. Not that state level committee approves. That is not the end of the matter.
After the audit, then you have paid up. What is this?
After the audit, audit has also approved. Audit has after the audit report, they submit. Then the central government direct the net fee that you disburse this amount. This is the procedure, my lord.
Okay.
So now, my lord, what happened? Lordship may kindly come to page 42, my lord. Page 42, my lord.
Yes.
My lord, page 42, here, my lord, it's a letter written, with reference to the above, I am to inform you that the following subsidies had been sanctioned against your claim by the state level committee in its 58th meeting held on 7 May 2009. Meeting was, my lord, in 2009, but audit was sometime in 2012, my lord, 11-12. You may contact net fee Guwahati for necessary disbursement, etc. So far, the, my lord, first item is concerned, that is interest subsidy, my lord. So for the second one was a transport subsidy, but my lord, 1408 to 3608, 1708 to 3908, these were disbursed, 2 period disbursed. Then next one, my lord, 1108, 311208, and 1109 to 31309. So these are the 2 periods, my lord, where they were sitting over the matter, my lord. Then, my lord, what happened when the amount was not disbursed, even after the, my lord, audit report, then, my lord, the petitioner approached the Honorable High Court, which your lordship will find, and my lordship may kindly come to page 46, the judgment, my lord. Page 46. But this is my lord. In fact, my lord, may I read, my lord? The scheme called the Transport Subsidy Scheme 1971 has been formulated and notified for grant of subsidy on the transport of raw materials and finished goods to and from selected areas with a view to promote growth of industries. The state of Meghalaya falls within the selected area A of the scheme. In the said area, the petitioner so and so has an industry unit. By letter dated 12/5/2009 issued by the respondent Director of Industries to the petitioner, it has been conveyed that the subsidy has been sanctioned against the claim of the petitioner by the state level committee in its 58th meeting held on 7/5/2009, and as such has been advised to contact Northeastern Development Finance Guwahati, this net fee, for necessary disbursement. The type of subsidy, period and amount sanctioned are as under. This, my lord, is reproduced again, my lord. Then, my lordship, may kindly turn to next page. So far, the subsidy of the period 1/9/2005 to 31/3/2009 and 1/4/2008 to 36/2008 and 1/7/2008 to 39/2008 are concerned, same had been disbursed in favor of the petitioner. Whereas, regarding the central transport subsidy for the period 1/10/08 to 31/12/08 and 1/1/09 to 31/3/09, amounting 2,33,44,000 has not been disbursed. Same has been conveyed to the respondent number 5, that is Malur central government, by Under Secretary to the Government of India by letter dated 2/9/2014, because the expenditure incurred by case on transportation of raw material finished goods is not permissible as per existing policy.
Yes.
Then let's see, it appears that for ensuring
payment on cash, expenditure incurred
yes,
by cash.
yes, my lord. Because my lord, central
I
government
mean, that is the key to the whole thing.
my lord, yes, yes, my
So
lord.
whether any cash payment was made at all.
Yes, my lord.
Okay.
Yes.
Yes.
It appears that for ensuring that the object for grant of subsidy is not misused, the checklist for scrutiny of claims under the transport subsidy scheme has been formulated as Annexure A and B to the letter dated 2011/2009, issued by, that is subsequent, my lord, issued from the Ministry of Commerce and Industry, Department of Industrial Policy and Promotion, which inter alia provides that all claims arising from transportation of raw materials and finished goods prior to 10/9/2009, Lord C, may I kindly see, will be examined, re-audited as per checklist A of 44 points. Point 35, which is relevant provides as under: bank statement for prompt payment made to transporters during the period, payment only by check. This is, my lord, in fact, the crux of the issue. Now, my lord, lordship will see the judgment. Press para 4. Precisely the point for consideration is as to whether point 35 for the period 1/10/08 to 31/12/08 and 1/1/09 to 31/3/09 will be applied vis-a-vis payment to transporters by check. The answer has to be no. The notification has been issued on 2011/2009. The periods for claim of the petitioner is 1/10/2008 to 31/12/08 and 1/1/09 to 31/3/09. During that period, he had no idea that he has to satisfy the condition of making the payment of the transportation by check. As usual, he has claimed to have made the payment by cash. Same he has done in case of other three claims for the period 1905 to 09, 08 to 08, and my lord, this period. The amount of those claims has been disbursed. To abruptly say that the petitioner did not make the payment by check for the periods when the notification dated 2011-2009 was not in place shall be illogical, even though in the notification the condition has been incorporated that all claims arising for transportation of raw materials and finished goods prior to 10/9/2009 will be examined, pre-audited as per checklist A of 44 points. Point 35, providing for payment by check, is introduced in the month of November 2009. Petitioner claims to have been made the payment of case during the relevant quarter on 31/3/2009. As such, the conditions, if applied retrospectively, will totally be illogical. Now, the question is as to whether the claim of the petitioner is genuine or not. Same position is clarified by respondent number 5 in the affidavit in opposition by annexing pre-audit report in respect of transport subsidy scheme sent by Under Secretary Government of India to the chairman cum managing director North Eastern Development Finance Corporation Limited NETFI. The pre-audit team during its visit on from 1/1/12, that is subsequent ballot, to 28/1/2012 of 64th SLC dated 35/2011 had at paragraph 67 to 68 dealt with the claim of the petitioner for the aforesaid periods. The remarks columns is recorded as under. This was reproduced by the Honorable Court, my lord. Lordship may kindly come to right hand side of the column. Right hand side of the column which has been incorporated in judgment itself, my lord.
Yes. But the doctor told you the same period they are coming now also.
Yes, my lord. Yes.
Second round litigation for the same period for non-release of the transfer study. Okay.
Yes. But how they have dealt, my lord, that I am coming to that.
Okay.
The lordship may kindly see remarks that is reproduced, my lord, from the audit report by the Honorable Court, my lord. Sanctioned by the 58 SLC held on 7509 but not audited. The present team audited the case on request of director of, as no such guideline was provided by DIPP, Director of Industries Promotion and Policy, my lord, DIPP in short, before issuance of 44 points guidelines about case payment. Hence, the case payment made to the transporters by the units have been allowed. That is the audit report, my lord. The audit report has gone in accordance with the, my lord, the practice, and my lord, exactly, my lord, correctly understood that it was subsequent to that. It was, audit was in 2011, and the so far the requirement of check payment was in November 2009. So up to 2 years. Then lordship may kindly come to, my lord, to both the period, my lord. Next page, lordship has come. Then next also the same thing. Next period also down below. Last few lines, hence the case payment made to the transporters by the unit have been allowed. That is the audit, my lord, the audit objection. They are recorded by the Honorable Court, my lord. Now, my lord, this it is very important, para 6 and 7. The object of avoiding misuse of the subsidy is achieved because the claim of the petitioner has been audited by the Pay and Accounts Officer, Ministry of MSMF. Therefore, there could be no reason for the respondents to deny the claim of the petitioner. That apart, it shall be open for the respondents if they so choose to re-verify. Yes, my lord. Here, my lord, here is the case. In fact, my lord, only, my lord, the Honorable Court give them handle. If you still feel that yes, something is there, you can re-verify.
Yes.
Re-verify, my lord. That was there. In case they have any doubt of audit conducted by the Pay and Accounts Officer, Ministry of MSMF, otherwise the amount shall be disbursed subject to adherence to the norms. That means if 50% is allowable, you don't require to pay 60%. Adherence norm means that is the norms. Whatever
when
norms.
When did this cash payments, check payment start? You said.
My lord.
When was implemented check payment?
Check payment from November 2009.
November. That means okay.
And so far the period of the petitioner is concerned that ended in March 2009.
31 3 years.
Yes, madam.
No, two periods. One 10,008 to 31 12,008, and once 1,009 to 31 3009.
Yes, madam. But there are 3 months period is there for as per the scheme. So they have to submit report for 3 months, and as per periodical they check up like that only, my lord. So, my lord, para 7 of the judgment, petition is disposed of with the direction to the respondents that they shall reconsider the claim of the petitioner in the light of the aforesaid observations, not beyond that, my lord.
Now, what did they do after that?
My lord?
What did they do after
yes,
that?
my lord. Let me compare, if you permit.
Yes,
For disbursement of subsidy amount, that is such and such amount for the period, the 2 periods I mentioned, along with interest from the date of pre-audit. That is, my lord, in fact, my lord, this was again after, my lord, 2 division bench judgments which attained finality and 3 single bench judgment. After considering all those things, my lord, that you from the pre-audit you make payment. Interest you make payment, interest also you are liable to pay. Now, my lord, Lordship will kindly see. Lordship may kindly come to Annexure 10, page 56. My lord, Honorable High Court judgment Honorable High Court judgment was 3rd May 2019.
Yes.
3rd May 2019, my lord. Now, my lord, on 2nd August, my lord, the order was passed.
Impugned. It's impugned order.
Yes, my lord. In fact, my lord, prior to that, they disbursed pursuant to the High Court order, my lord. The Lordship may kindly see page 50, Annexure 8, but again distorted. They passed the order again coming.
What amount did they release in 2008? I mean that.
they estimated something, my lord. They estimated something, they paid. So that's why, my lord, I have skipped this one. I will come next, my lord. So that's why straight away I came to.
You have paid 1 crore 98 lakhs.
Yes, my lord.
Then what remains now?
Yes, they paid. But combined, my lord. Combined, both the demand were there, but combined they paid something. But here the calculation they have not shown. That's why I have come to the order, my lord, which you will find it, page 56, Annexure 10. You may read, my lord.
Yes.
Whereas Mr. Meghalaya Pitts has filed writ petition number 389/2014 and 390/2014 in Honorable High Court of Meghalaya owing to disobedience of disbursement for cash payment of transport subsidy. This is the heading, my lord. Now, my lord, and whereas the Honorable High Court of Meghalaya in its order dated 3/5/2019 has directed that the petitioner is disposed of with the direction to the respondent that they shall reconsider the claim of the petitioner in the light of the aforesaid observations for disbursement of subsidy amount, such and such amount, such and such amount, to respectively along with interest from the date of pre-audit report, and to pass appropriate order thereon, whatever permissible under rules within the period 4 weeks. That is, within 4 weeks, my lord, they made payment, but according to their own calculation. And whereas the department has examined the extant procedure in respect to subsidy disbursement under transport subsidy scheme, the claims of the applicant are first examined by the General Manager, District Industry Center at the state level. The recommendations of the GMDIC are considered at the Directorate Commissioner of the concerned state and thereafter placed before the state level committee. On the basis of recommendation of the state level committee in accordance with the provisions of the scheme as amended from time to time, recommendation of SLC is forwarded by the Directorate of Industries to this department, that is central government, my lord. The department thereafter arranges for pre-scrutiny. Based on the pre-audit report, further action is taken by the department to release funds to Northeastern Development Finance Corporation NEDP, the designated nodal agency for disbursement of subsidy in Northeastern region for onward disbursement. Here, my lord, whatever I was submitting, everything is incorporated here, my lord. Now, my lord, see, my lord, this is very, very important, my lord. And whereas the claim denied is for the period 1/10/2008 to 31/3/2009, which the Honorable High Court has ordered to review, reconsider. My lord, here, my lord, they distorted the word. Review, reconsider, and pay. Since this subsidy claim during the second half 8-9 is significantly higher than the paid in the first half of 2008-9, which has been denied on account of cash payment. Now, my lord, before completing, my lord, may I, my lord, come to the here. My lord, here, my lord, so my lord, let me complete, my lord. Since the subsidy claim during the second half of the is paid denied on account of cash payment, the PIPT reviewed the denial order and agreed to pay as much subsidy as was paid in the first half of 2008-9, that is such and such amount. Under the given circumstance, this period, this should be considered fair and reasonable. Now, my lord, here is the very important issue is there, my lord. This is, my lord, the payment. They consider that what is reasonable, what was paid earlier, my lord, it is a not grant, it is not donation, it is not mercy, my lord. The transport subsidy is to be paid based on the calculation. It may be higher, it may be lesser, it may whatever it may be, my lord. So whatever paid earlier period, that will be reasonable, meaning thereby, my lord, they are sitting over the scheme and they apply their own mind, which is not permissible, my lord. It is not permissible. How they can say that, my lord, the subsidy?
Excuse that the payment made in cash.
My lord.
Again
repeated, my lord. Paid it case. My lord, issue already settled that, my lord, case payment was prior to the notification issued for check payment in November 2009. This period relates to prior to 31st March 2009. Again, my lord, they said it is case payment. So, my lord, because you are again reiterating the same thing which has been already settled, meaning thereby you are illegally withholding the issue, you are illegally obstructing in the payment of the transport subsidy and taking your own decision. Then at that apart, under the given circumstances, it should be considered fair and reasonable. What fair and reasonable, my lord? Fair and reasonable, not that you are not doing mercy. And my lord, even the division bench of the Guwahati High Court, my lord, it has been already, my lord, held that it is not a largesse, it is not a donation you are giving. It is under the scheme.
Now they released. Now the last paragraph, therefore, a matter pending claim because of the decision of the High Court, total amount of which 1 crore 98 has been released.
Yes, but now, man, what happened? What did they do? Again, based on the earlier payment, they paid an interest 8%. That also not from the period. That are 1 year after 1 year, my lord, they made. But they are also that's my lord in our priorities there. But the amount again considered that whatever paid earlier 2 period, that was reasonable. So, my lord, so far this, my lord, in fact, my lord, this scheme, it may be more, it may be less. What is because the authority is not given to the secretary, my lord. Executive authority is not given to the authority.
But orders only want to impugn, that's all.
My lord.
And what subsequent action by the respondents after that? He represented against this.
Yes, my lord. Now, my lord, now the issue is there, my lord. Again, my lord, let me read, my lord, the last page 57, my lord. Here, my lord, interesting issues are there, my lord, which are under the given circumstances, this should be considered fair and reasonable because DPPIT don't trust the cash payment. Again, my lord, reiterating the same thing, my lord. Then, my lord, meaning thereby you are obstructing, illegally withholding without reasonable cause. You are sitting over the matter deliberately, intentionally. And my lord, even my lord, this is my lord something unheard of. My lord, after a High Court order, it can be distorted in this way. Based on subsidy scheme, first up 809, made by check, that is plus simple interest 8% per annum amounting what? So this one, the rate of interest 8% honors the rate as decided by the Honorable Supreme Court in the case settlement of dues to State Trading Corporation, copy enclosed. They have said 8% is the reasonable based on Supreme judgment. The payment of 198,52,054 is in order since the checklist of transport subsidy provides for payment of transport only by check. Payment made in case are ineligible for reimbursement. So that's why they did mercy. That you made payment by case. Yes. When the requirement is by check. Yes. So we are doing mercy upon you that whatever the reasonable paid, whatever donation we gave you earlier period, that donation again we are giving you. Whether that is permissible under the scheme, my lord. Now this is the question, my lord. So, my lord, that now therefore the matter is of pending claim of Messrs. Meghalaya Fits has been examined in accordance with the directions. In accordance with, this is in accordance with, my lord. This is in accordance with, that is your...
What part of accordance?
Yeah, accordance, my lord. This is in accordance. As per their understanding. It is, my lord, deliberate, intentional. My lord, even, my lord...
Why you do the contempt?
My lord?
Contempt was filed also.
Contempt was filed, my lord, then, my lord, the Honorable High Court observed that since the order has been passed rightly wrongly, and my separate cause of action is arisen. So because
Exactly. Now why you've come again here?
so because my lord, the personal litigation, because they passed the order, they said that we have complied with the contempt proceeding. Whatever the direction was there, we reviewed. So High Court under Lordship also is aware that under contempt jurisdiction, case cannot be heard afresh. Will you comply or not comply? Let me complete, please.
There's some very relevant fact here. In fact, we also filed a writ appeal against the single logistic judge of my lord. And one important observation in that writ appeal is, my lord, your lordship kindly to page 73 of my counter affidavit, my lord. They have not annexed that.
My lord, I'm reading their affidavit. All the
question of law is.
My lord, all the contents of their affidavit, net fees affidavit, I will read everything, my lord. I will not suppress anything.
It's very relevant. We can have a look at it first. But
my lord, I will read everything, my lord. Let me complete first, my lord. Their affidavit, I will reiterate everything, my lord, because I have only come to the petition only. I will read their affidavit, net fees affidavit also, what they said. Where,
net
how.
fee counsel is not here, I think.
But net fee has no role at all, my lord. They are disbursing officer, simply disbursing officer. They are simply disbursing officer, my lord. So, my lord, in view of that, so still is my lord, my lord. Let them, my lord, because another date may be fixed, my lord, then they will also make their submission. But let me complete, my lord, first. Now, my lord, I am coming to that, my lord. Now, what their affidavit is, and what, my lord, what the Supreme Court says, where they have gone to Supreme Court. I am coming everything to that.
Supreme Court also after that.
No, but Supreme Court against interest they have gone. Against interest they have gone to Supreme Court. That too also, my lord, in another case, that's a court said that status quo. Court has not stated or the other two judgments. That, my lord, J. Tariq's judgment can.
No, the thing is that now whether you can claim interest, that's the question.
Yes, my lord, they can claim interest. Interest, my lord, because in the Supreme Court judgment, my lord, Ghaziabad case, my lord, the Supreme Court held that, my lord, interest, my lord, in the appropriate case, interest can be given in spite of the fact that there is no condition contained in the contract that the interest is stipulated interest is there. Still then, but if my lord, then my lord, I am coming, my lord, to some judgments, my lord, then my lord, my friend will make a submission and I am coming to their affidavit, what they say.
So, Dr. Tori is summarizing now, you not come next date, that means not required for you to come anymore.
My lord.
So, the next date not required for you to come anymore.
I will come, my lord, I will come, my lord, but only, my lord, because since my lord is lingering for last many years, and my lord, why I am submitting this thing, that also, my lord, I will satisfy your lordship, my lord, why I am pressing hard, my lord, for this case, my lord. That also I am coming to that, my lord, so that, my lord, my friend cannot have the in mind that, my lord, why I am pressing hard, whether this matter can linger for so many years, my lord.
It's a 21 matter.
Not 21, 2014 matter. 2014 matter, my lord. 21 matter, my lord. 8 times they took adjournment to file affidavit. They took 1.5 years to file affidavit. Central government. It is this case, this parent case, which is parent before lordship, my lord. There is a record says, and I can give the date. It's everything recorded, my lord, in my file. Whether they are permitted to act in such a way to withhold, to sit over the disbursement of the payment, my lord, I am coming to that, my lord. First I will come to their affidavit, my lord. Then, my lord, I will show the judgment, my lord, why, my lord, it is such important, my lord, and why interest was levied. Their affidavit, my lord, so will kindly see what they say. This is, my lord,
by the state first.
Central government.
For the state.
They do not file an affidavit. They have nothing to say. They have no affidavit. They have filed an affidavit. Net fee has filed affidavit. Net fee said we are simply dispersing officer. That also we read, my lord. Their affidavit, what they mentioned in the affidavit. And the, my lord, central government affidavit, that, my lord, I am placing before you, my lord. This affidavit, my lord, is, my lord, omnibus affidavit. And, my lord, it's like everything there may misuse, this thing, that thing, many things are there. Very briefly, my lord, I will just read what they stated, my lord, in their affidavit. And, my lord, they said that, again, they said the cash payment is required, otherwise there will be misuse. The same thing they reiterated. What, it's a duplicate affidavit, the same, my lord, replica affidavit of what they filed in earlier litigation. Same affidavit. Exactly same affidavit they file again.
No, but it doesn't mean that we have come down to a point of interest.
My lord?
Only point of interest only.
No, not only interest. Not only.
What is the law question is left open?
My lord,
what law question is here?
My lord, first is whether interest is payable on subsidy, my lord. That is one aspect of the matter. Second aspect of the matter, because the learned single judge, my lord, Justice Meer's order, that also says, my lord, that apart it shall be open for the respondent if they so choose to re-verify in case they have any doubt about the audit conducted by pay and account officer. But it was not a case that the learned single judge gave us a clear direction, because it was little left open for us to.
Okay, at the division bench, what was the law question?
But the division bench said that whatever the legal issues are there, they'll remain open.
Yes, Doctor, continue. Well, yes. No, you didn't let him. You continue. Yes.
Well, I will come to that, my lord. Even my lord, what Supreme Court said, why interest was paid, everything I will place before Lordship, my lord. Then my friend will have the ample time to give counter to that, my lord.
Because all the respondents are not here, my lord. But Dr. Todi will have to come in any case, my lord.
No, I will come, my lord, but whether all the respondents' presence is now required or not required, my that your lordship will, from the facts of the case and what the matter, whether required. But I will proceed the important department, central government is present here, my lord. They just give money to net fee that you disburse. They are only, my lord, like job of accountant, not accountant, my lord, in the banker only. Whatever balance in my hand, disburse that. That's all. Their affidavit, I will read from their affidavit. I think my friend will accept to that. Now, my lord, their affidavit, so far the affidavit is submitted by the central government, is a completely, my lord, replica of the earlier affidavit filed before the High Court, my lord. And here the same thing, my lord, again and again, they said cash payment was made, so my lord, and to my lord, prevent misuse and all, so my lord, the amount cannot be paid. And my lord, whatever the order passed, because order passed subsequent to that, my lord, the affidavit is prepared by them. So they said that because the whatever paid reasonably, whatever paid earlier period, that payment was made. So this may be considered reasonable. That's what. So my lord, whatever that is permissible under the scheme. So in my respectful submission, my lord, that is not permissible. It is not, my lord, largesse. It is not a donation. It is not a mercy, my lord. So my lord, if they are payable, payable. If not payable, not payable. In between, they have no choice, because scheme does not give permission to them to take a decision on that count, my lord. If something is there, let my learned friends show that scheme or any amendment to that modification of the scheme where the liberty is granted to them to sit over the scheme and take their own decision as per their own sweet will. So next date, my lord, my learned friend can apprise the Honorable Court or that modification part of it, where this executive authority is given the liberty or authority to sit over the, my lord, is having a scheme having the force of law. But a reply, we have also filed a reply to the affidavits by central government, my lord. Here, my lord, we have stated, if you may only, my lord, read, my lord, if you permit me, lordship may permit me, my lord, to read.
Yes, please.
To whatever reply filed to the affidavit in paragraph 5. With regard to the statement made in paragraph 8, paragraph B, C, preliminary submissions in the affidavit in opposition.
We're reading from the affidavit.
Reply, my lord, our reply, my lord, what they said, because we said it is reiteration of the facts. Only
what is said in affidavit? What is the contention they raised?
Well, in fact, the affidavit, my lord, they say that, my lord, what I was trying to present before lordship, my lord, that the affidavit is nothing but what the order incorporated, my lord. That is paid by cash, or my lord, that misuse this thing, that thing, this.
Or single bench order.
Yes, my lord, same thing they repeated. That's what, my lord, I try to, my lord, present before lordship, my lord. And my lord, whatever we said in the, my lord, our affidavit reply, there stated that it is only a repetition of the same thing. Whatever this is on record, my lord, in our affidavit reply. Because we said that as such, the respondent 1, Union of India is stopped from raising the same issue, facts and circumstances to deny the claim of the petitioner. The same thing you are raising again and again. And so far the net fees affidavit is concerned, my lord, that also lordship I bring to notice of the Honorable Court. the net fee in paragraph 5 what is their role, they said. Before replying to paragraph wise lead petitioner, the respondent would like to describe the role of respondent number 5, Northeastern Development Finance Corporation, which is designated nodal agency appointed by Government of India for the purpose of disbursement of Central Capital Investment Subsidy Northeastern State under the Northeastern Industrial Policy issued by the department. The responsibility of admitting claims from units, process them, computing the eligible subsidy amount, and finally recommending the same by disbursement rest with the concerned state government release fund to the Northeastern Development Corporation along with the list of units to whom it has to be distributed and how much to be distributed in respect of clarified claims. Northeastern Finance Corporation accordingly disburse the fund to the individual units as approved by the Department of Promotion and Policy. Their role is, my lord, they have themselves described in the affidavit. They have nothing to say that with regard to the policy is concerned, my lord, as per their own affidavit, my lord, net fees affidavit. Now, my lord, but this is compilation of judgments, my lord. My lord, with regard to the interest and other issues, my lord, but now, my lord, Lordship may kindly come to first judgment. This is Under Secretary, Ministry of Industries, Markham Textiles, 2005, 10 SEC 554. But here Lordship may kindly come to para 8, running page 4. The schemes floated by the state releasing grant of subsidy for industrial units. This is, my lord, the Markham Textiles case, my lord. The scheme floated by the state releasing grant of subsidy for industrial units to be set up in certain selected backward districts areas have benevolent and public purpose to achieve, and that is to promote the growth of industries in such district areas which, but for the state encouragement, would continue to remain backward, and industrial investment will not be attracted to such areas. Such schemes have to be construed with practical and pragmatic approach so as to achieve and not to frustrate the purpose sought to be achieved. Now, my lord, the action shown by the central government in implementing the scheme by the executive in disbursing the payment is nothing but to frustrate, my lord, the object sought to be achieved by the scheme promoted by the central government. The benefit of the scheme ought to be allowed if it can be done. The application should not be dealt with a hyper-technical approach or in a pedantic manner. If the application filed before the cut-off date, that is, my lord, a cut-off date, because the application to find the cut-off date, that is as per the scheme, is substantially in order and satisfies the formalities expected. In fact, my lord, some, my lord, the conditions were left out, because then, my lord, court held that substantially, my lord, if it is complied with, satisfy the formality expected to the scheme, then the opportunity should be allowed to the applicant to cure the defects which are not of substantial nature or are capable of being cured, so that the deserving units are not left out of the scheme. This is very, very important judgment, my lord. Subsequent, all the judgments, my lord, these Markham Textile judgments were followed, and, my lord, the interest was also paid because of after following the Markham Textile judgment, my lord. 2005. Then, Lordship, my lord, I mean coming मतलब lordship में मतलब the division bench judgment my lord, though my lord the judgment has been travelled to Supreme Court for the purpose what the interest was levied my lord, but that also judgment I will refer my lord what my lord interim what Supreme Court said. Lord, my lordship may kindly this judgment, division bench judgment my lord, lordship may kindly come to page 48 of the judgment.
Running page 48.
Running page 48 my lord.
Sir, nor the list nor copies given to us.
I will give. These are the judgments you are known to everyone. But he was referring Supreme Court matter. These judgments he was referring to my lord. Ishwar Food Products. This judgment I am referring.
Ishwar Food.
Ishwar Food my lord.
Ishwar Food.
This is my lord. What my lord? Para 20 lords may kindly see. All of the judgments my lord. Para 20. The respondents under the scheme had no discretion. Respondents under the schemes had no discretion to either not release the subsidy claim or delayed payment of subsidy by virtue of such action. The public servants have indulged in discouraging the investors from coming to notice. The very purpose of floating the scheme would be defeated if subsidy is not released within reasonable time of its maturing for release. Under these circumstances, the applicant has been able to make out an appropriate case for award of interest on delayed release of subsidy. If such a scheme of respondents are accepted by court, which is also court of equity, manifest injustice would be caused to the rights of the applicant. Subsidy is not a largesse that is being given by the respondents. Rather, every person who complies with the conditions of the scheme becomes entitled to payment of subsidy. Now, my lord, I wanted to just learn and to understand what the largesse means, my lord. Though, my lord, then I went to the dictionaries, my lord, to declare exactly what honorable court, my lord, intended to say with the word incorporating the word largesse, my lord. My lord, as per the Oxford Dictionary, my lord, it says largesse means the act of quality of being generous with money. Money you gave to people who have less than you. That means my litigant is definitely less than the central government money. So my lord, give my lord. So that is my lord largesse. So it is not largesse, my lord. As per the division judgment, it is not largesse. It is a scheme, my lord. As per the scheme, which is permissible.
Yes, you incur expenditure on your own, which you are seeking reimbursements for a scheme. So it is not largesse.
My lord. Then Oxford Dictionary also says the charitable or generous giving. So my lord, they say it's reasonable. It will satisfy them because we are giving you, that is reasonable, satisfy you. That means last time whatever we do give donation, you take that, whatever you give, something. So a present, a gift or donation given unselfishly, that is largesse. So my lord, the honorable court has, after dealing with the case and going to the scheme, provision scheme.
This is not for the Supreme Court judgment, Ishwar Foods Guwahati High Court judgment.
No, in fact, my lord, what I am to say, even my lord, very often, my lord, they say that whatever we give, that is reasonable. This is all right. So, my lord, while dealing with the case, honorable court held that no, it is not that. It is as per the scheme. It's a grant as per the scheme. If the more is payable, more will be given. So, whatever paid earlier, suppose, my lord, I asked a question to myself. If the amount claimed would have been less than the earlier period, whether they would have been given the same thing? No. It is the whatever the SLC approved based on the calculation, whatever the internal audit, my lord, audit report said, whatever that amount is to be payable. That is the purpose of the
on actuals.
Yes, my lord, on actual. So, my lord, by putting the word, by reviewing and by applying their own mind to test the reasonableness, perhaps frustrates the object sought to be achieved by the scheme, and the scheme never intended that.
Yes.
That's what, my lord, I am trying to establish, my lord. Now, my lord, so far the interest is concerned, my lord, as per the High Court judgments from the date of pre-audit, my lord, so they have recalculated not from the date of period. And one issue is that they have given not as per the payment payable, as per the grants payable, as per the audit report, but they took the whatever they paid earlier. Number one issue. Second issue that, my lord, they calculated interest, though they paid interest as per direction of the High Court.
One thing that was told in your prayer said directly respondents should disburse a balance amount. Or
Yes,
total sanction
yes,
amount.
yes. Lordship, I am coming to prayer also. I am coming to. In fact, my lord, in when my lord, the Supreme Court judgment, I think 2003 or Goddess thoroughly, in absence of specific words contained in prayer, my lord, from the submissions made in the petition, if transfers, my lord, in absence of specific word, my lord, even then, my lord, court can give, my lord, the specific relief. In Goddess Salis Supreme Court, my lord, teacher judgment is there, my lord. 3 or 5 judgment, my lord, I forgot that, my lord. But I am coming to that, my lord. Even in the petition, my lord, we made the prayer, and in the prayer also, it is mentioned, my lord. Page 21 in prayer, as to why payment of interest on the claim amount should not be granted at the rate 12%. Of 12% per annum from the date of pre-audit till the date of payment.
Yes.
That means, if they made the calculation mistake, that is to be paid. Here, on page 20, we elaborated it. Page 20. Page 20 in our petition, we elaborated that. But here also, we have maintained the prayer also. So, meaning thereby, they have to pay interest, though 12% not paid, to 8% they paid, but that has to be from the date of pre-audit. But not from other date, they cannot calculate other date, my lord. That is second. Now, my lord, so far interest is concerned, because my landed friends, my lord, Ori was that interest was not payable, and my lord, the matter is pending before the Supreme Court. But Supreme Court, my lord, Iswar Food Product case, my lord, they went to Supreme Court. Supreme Court is status quo. Status quo with regard to the, my lord, Iswar Food Product. But, my lord, prior to date, my lord, that is not be stayed, not set aside, but two judgment still holds the field. The two judgment that, my lord, in the Iswar Food Products case, that J. Tarang's matter has been referred to, that, my lord, that interest in equitable considerations can be given. And, my lord, in the Iswar Food Products also said, in Ghaziabad case, my lord, that even, my lord, there is no, my lord, scheme for paying interest, but if they sit, my lord, now, my lord, it will be clarified, my lord, that I'll come to that judgment. Lordship may kindly come to first, my lord. Running page 14, my lord, that Union of India versus J. Taring, it is Union's appeal, my lord. 2013, my lord, way back, 2013, 10 years passed by. Page 14, running page 14. Shillong bench judgment. My lord. Lordship may kindly come to page 19, running page 19, para 17 of the judgment, my lord. May I read, my lord? As has been noted in Markham Textile, Supra, that judgment, my lord. That, my lord, is a violation of public purpose to be achieved. So, my lord, they cannot take hyper-technical decision, but they should be liberal. The schemes floated by the state releasing grant of subsidy for industrial units to be set up in certain selected backward districts areas have a benevolent and public purpose to achieve. That is, my lord, quoted from Markham Textile judgment, my lord. But for the encouragement of the promote growth of industry in such areas, district, these areas would continue to remain backward and industrial investment will not be attracted. The petitioner had set up its plant in a remote area of Jaintia Hills district and was heavily dependent on transport subsidy at a nascent stage for its viable existence. The claim of the transport subsidy are to be submitted within a period of 1 year from the expenditure incurred. A corresponding duty is also cast upon the authorities to disburse the claim duly made and sanctioned within a reasonable period. The learned single judge directed payment of simple interest from wrongfully withholding the transport subsidy. we see no reason to take a different view, and accordingly, directions of learned single judge to pay simple interest at the rate of 12% per annum is upheld. Yes, we have held that the writ petitioner will be entitled to transport subsidy only from the period such and such session. The interest will be payable only in respect to the amount in terms of the direction of the learned single judge. Here, my lord, because of the illegally withholding the transport subsidy, interest was paid. So here is the, my lord, this is also a fit case where it can be, my lord, a conclusion can be drawn that they illegally sitting over the issue. And here even after the Honorable High Court judgment was passed, my lord, again, my lord, they illegally set over the matter from 2019 onward, my lord. Then second, this attempt to file a demand as against the judgment 2018 Union of India versus J. Tariang, my lord, the matter did not went to Supreme Court, my lord. So this holds the bill. Secondly, my lord, then again, this judgment was repeatedly followed in other judgments, my lord. That page 30, your lordship may kindly see. Page 30.
All got High Court.
You got High Court, but following by J. Tariang was the leading. J. Tariang judgments, following J. Tariang judgments, interest was, my lord, again, para 5. In the case of Union of India, J. Tariang, division bench of the has a, this one, of the apex court, appropriate authority of the apex court has taken serious note of delay in payment of subsidy, para 5, my lord, running page 31, subsidy. In the said case, the division bench has directed the authorized to pay simple interest at 12% from date of submission of the claim application. Here, my lord, again, judgment, my lord, J. Tariang was followed, and my lord, interest was directed to make payment. Then lordship may come to page 33, running page, that again Barak Valley. Here also again, my lord, J. Tariang, Union of India. My lord, may I read, my lord, para 10, running page 37.
Yes.
Very well. So and so also submits that the transport subsidy have been availed by the petitioner company over the years, and the same cannot be denied on account of observations made by CNAG, and there was no proper scrutiny prior to recommending the payment of subsidy. Moreover, now the Ministry of Commerce and Industries has clarified the applicability of the scheme to the Northern region. There is no reason for the respondent authorities concerned not to release the transport subsidy due to the petitioners. He also submits that affidavit in opposition filed by respondent 5 clearly indicates that the subsidy amount has not been released to the petitioner only for lack of proper scrutiny in the department prior to recommending the payment of subsidy. So and so submits that petitioner in fact have no role in scrutiny besides providing the necessary documents and materials while making the claim for subsidy. The same thing matter they are referring to. The ground of denial for denial of subsidy is only vague and does not reveal. Also, considering the facts of the clarifications has already been made. There, my lord, in that case, what happened? Clarification is issued. Thereafter, they are also sitting of the matter after making clarification also. Meaning, thereby they are using their discretionary power for the delay in releasing the subsidy amount. So and so submits that.
This order was honored.
My lord?
This order was honored in letter and spirit.
My lord, see, J. Tariang, my lord, is the whole field, so again, my interest was directed to be paid, and it was paid also. Now, my lord, should I complete, my lord, if you look permitted? For the delay of release the subsidy directed for interest and has been ordered in the similar cases, he relies upon the decision of this court passed in the Union of India versus J. Tariang reported in 2013-2. Divisions in the court, divisions of this court taking note of the fact that it was due delay release of the amount was keeping.
The quantum is more here.
My lord?
The quantum is more here or less here in this case.
My lord, the question of quantum less or more, my lord, the question is that, my lord, theory, my lord, even 100 rupees also.
The principle even.
My lord, in fact, my lord, here, my lord, what happened in one case, 90 lakhs was to be paid as conversion, and interest was paid 1 crore because of illegally sitting over the matter. But the High Court directed, then they went to Supreme Court. Supreme Court also dismissed their case. Because his question is this, my lord. When, my lord, the benevolent public purpose is to achieve the purpose when the scheme is floated, my lord, the meaning thereby, my lord, whether the executive authority can interfere, sit over the scheme, policy scheme, yes, my lord. If they have any ground within the scheme,
No,
yes.
but has a window been given by the division bench when they went an appeal? A window has been given to the respondents to reinterpret the, regard to this point of law, point of interest.
No,
That's
my
the only
point
thing.
of law, point
So,
of it.
the thing is that
No, what is that? Let me show the judgment, my lord. I am showing the what Supreme Court said, my lord. I have to copy.
That's what the division bench said when they had gone on appeal against this order. That is what he was trying to place.
Which one, my lord? This judgment, my lord.
The division bench judgment against this particular
Earlier order, single benches, my lord.
No, there was an appeal.
They have not gone to appeal.
It's here, my lord.
What is the order? Let me see. They have withdrawn it.
The legal issues involved is left open for consideration in an appropriate matter.
Yes.
Appropriate manner means this is an appropriate time.
Yes. Appropriate bench is now. This is appropriate bench, my lord. This is appropriate bench.
I'll place my case.
They have withdrawn the appeal. They have withdrawn the appeal.
Because after receiving the money pursuant to the order of the learned single judge, my lord, we have disbursed a certain amount of money. They very happily received that amount, my lord. Then they went to file a contempt. They withdrew the contempt, and now they
Happily,
come.
my lord, it is their word, my lord. We have not said happily, my lord. No, nothing recorded happily. My lord, we have read contempt was filed immediately, my lord. Not happily, my lord.
Then
So the question of estoppel will come, my lord.
Accepting the amount.
Accepting the amount.
You bring authorities on that.
There are other issues also, my lord. I'll raise all this.
We left it after.
Because why we reduced the amount, my lord? Because in the same financial year, my lord, in the first half, from March to September and September to March, my lord, in the first half, amount is very less, my lord. Their own claim, my lord. In the second half, they make cash payment to the transporters and they inflate the amount, my lord.
The first payment was check payment.
My lord, that
That was small.
because the amount was not so significant, my lord, in the first half, so we agree to that claim, my lord. But when it comes to second half, my lord, the claim is.
How many times it went up?
It's quite
The
substantial, my lord.
difference.
I'll place that also.
You can't really say that, because that's all factual aspect. That before they transported more produce.
And moreover, cash payments, there are limits on cash payment by the government.
We'll look at that.
So on that basis, we rationalize the amount in tune with the claim of the first half, and we paid that amount.
But can you rationalize the amount such a way when it's already been passed by the state, what's that, SLC, state level
But there is no
committee,
dispute
and
that-
by the audit done by you only?
But there is no dispute that amounts are paid by them in cash, my lord. Because after all, these are government funds, my lord. These are not for grabbing just without any right, my lord.
Okay. When do you want it out of study? Even the MS.
My lord, one thing, my lord, with regard to my submission, my learned friend, that he made a submission that we can limit. So, my lord, that also notification can be given where they can authority to limit. The word used limit.
No,
So we can limit.
rationalizing the.
What is that, my lord? They have to, my lord, it's a discussion. Where discussion is given. So discussion, my lord, yes, my lord, everything is, my lord, so what, my lord, the other things are concerned, my lord, see, and the statement, vague statement, political statement is all right. But my lord, that has to be, my lord, transferring from this provision of the scheme. They cannot use their discussion as per their own sweet will. That will
We have to look at from reasonableness.
My lord?
Also, from the angle of reasonableness. Whether the action of the respondents is reasonable in the circumstances.
Whether the first writ petition itself was maintainable, my lord.
Now they can.
They came.
Now the thing is that
it was in the nature of a money claim, my lord. That and they come after 6 years. That was clearly time bound, my lord. But somehow or the other that was not raised before this honorable court, and
this is, my lord, strange submission outside the pleadings, my lord. My lord, outside the pleading.
No, for them, they are seeing a mandamus only as per the scheme. See, there's a amount of executive instructions which you are bound by. So there's a scheme that is in place. So they are the beneficiaries of the scheme. So naturally, it's not a question of commercial dispute.
But the legal issue only is there was certain checklist before 2009, my lord, and a new revised checklist was issued after 2009, my lord.
But only legal issue, my lord.
That is only legal issue. Whether
Only
the
legal issue, my lord.
subsequent
Retrospectively,
checklist-
they want to make, but whatever I come.
You say what is the legal issue only?
My lord, in 2009 November, after the CAG's observation, my lord, we issued a revised checklist, and one of the components of the checklist was that the payments must be made in through bank account, my lord.
Okay.
So they came before this honorable court saying that this checklist cannot be retrospective. This can only be prospective. But still, the learned single judge of this honorable court, my lord, gave us the liberty to still re-examine the matter.
They have not doubted the audit report. If they, my lord, now the question is that, my lord, if they have doubted the audit report, then they would have a case.
That is why state is.
But they have not doubted the audit report. They said that you made the case.
That is an important
Have
point.
you filed an affidavit?
They should file an affidavit, my lord.
Because the committee also is your committee which is vested the power to assess on the ground itself. Do you maintain any records of the whatever documents have been submitted by the petitioners?
If you can bring, you can produce that, my lord.
You produce the records otherwise.
How much is
Then
cash
become the
payment?
nature of otherwise another thing that angle that comes is for consequential benefits you're seeking here.
My
It's
lord,
not for the primary benefit. Consequential in the sense that there's aberrations in the
My lord.
computation.
my lord, if lordship permits me, my lord, may I submit one thing?
Yes.
My lord, everything, my lord, in fact, like my lord, the mechanism, my lord, incorporated in the scheme, that my lord, the state level cooperative will scrutinize. Who are in the state level committee? Finance persons from this finance, secretary finance, secretary industries, my lord, one nominated from central government, director of industries.
Nothing is foolproof, Dr. Tori.
My lord, my lord, then in that case, my scheme may be closed down. But for that, my lord, why my
The
lord,
scheme closed down now. It's closed down.
why genuine person will suffer?
I think this Mr. Todi will know.
You're still enjoying the scheme now. Also.
My lord, in fact, my lord, my only apprehension is that, my lord. In fact, my lord, everything said, but who is doing what, I am not concerned with. But so far, my case is concerned, because whatever the level is concerned, because it is duly scrutinized.
So now
duly
you're
audited,
entitled to what payment?
I am entitled to my lord, the payment which I claim, which is the SLC.
The difference from what the past assessed amount and what they've paid.
No,
They paid you 1 crore 98 lakhs.
my lord,
That includes interest, my lord. 60
my lord,
lakhs of it.
because they cannot make reasonableness. It has to be whatever the SLC approved and audited by the team, central team, my lord. That amount has to be paid minus whatever they paid, the balance amount along with the interest. And but whatever mistake they did in the interest earlier part, that has to be calculated. It is, my lord, question of law, and that is the law. Because my lord, now the question is this, my lord. Now question is this: what my landlord friend trying to establish again and again, the cash payment. My lord, now, my lord, when my lord, the case was, check system was subsequently introduced, earlier payment case, whether I will go to the all the transporters all over the country, searching them that you now check.
That is irrational.
Then, my lord,
Yes, but when do you want it, Dr. Mozika? Just give a date. We just heard because Dr. Todi wanted to make preliminary submissions on the matter. So he's already concluded submissions, I think.
No, my lord, if in fact, my lord, my landed friend, suppose they want to make defined angle outside the pleading, then I have to adequately reply to that, my lord. With these judgments, my lord.
But sum and substance, your pleadings are complete, yes. Heard in part, this is a matter for further hearing on.
Third, my lord, third.
No, third will not be possible.
Then, my lord, can it be on 6th?
Not be possible that week because I'll be traveling again by the after tomorrow.
10, 11, 12, 10.
On
the 10th, my lord.
The week after that, my lord, 18, 19, 20, any days.
No, my lord, then, my lord, difficult, my lord.
Then have it on 12.
12.
It's on 12. MS Al Kolni, another G also to obtain instructions. 2 to 4 years. You're here, Mr. Wanyang, no? Your name? Mansur, sorry. Yes. Your seniors on leave.
In fact, my lord, it is not proper to say many things, my lord, but everywhere, my lord, with the same thing, my lord, they are sitting with the matter, they are showing their own discussion, and then my lord, they are paying interest because interest has been directed to pay. Then when it comes to interest, then just to safeguard themselves, file appeal here, there, just to protect themselves.
One thing I don't know, my lord, because they say there is a partnership firm, whether the firm still exists.
That your affidavit should speak everything. Where is affidavit says that firm does not exist?
I don't know.
This is a very strange statement, which is the uncalled for.
We'll examine that.
Yes.
You go to CBI.
Please don't be personal.
No, why you are saying the fund does exist? Because what affidavit says firm doesn't exist? We have a central team at audited. Central team at audited, my lord. Central team at whether you are above the central team.
Please, I respect you, you are senior, but please don't behave like this.
No, it just exists, my lord. This is strange.
Yes, Dr. Tori, please. It's all right. Both of you are doctorates. I mean, doctors. Dr. Mozika and Dr. Tori. I mean, we have to set an example. Yes.
32.
Yes, Mr. PT.
This lordship, regarding pension lordship, actually this is only small issue. What happened actually, he was appointed. They are not disputing my permanent employee. Actually, I was retired on 2017. 17 and then 2017, and they're supposed to pay the due retirement benefit to the and the pension.
Sorry. When they retire?
Okay, lordship, actually. First, I was appointed in the year of 1995 on 5.
No, when did he retire?
Retired, my lord. It was 2017. 2017.
Okay. You're not being paid pension till now.
Release, lordship, release on with effect from 31st March 2017.
Okay.
Then, my lord, the petitioner actually is the wife of the deceased lordship. He has married. The marriage certificate also is enclosed. But since I was retired from 2017, but the service benefit and petitioner that pension and others has not been released to the petitioner only on the ground that there was a mistake on submission of the birth certificate.
On the
birth certificate, they said that as per the birth certificate which admit card in embossed issue, birth certificate.
Where's the
lordship,
where's the letter you agree with?
Yes, lordship.
Where is that?
May I take you to the page para 11, page 4 of the affidavit in opposition filed by the state respondent.
Para
11, paragraph 11, lordship. Paragraph 11, lordship.
Yes.
Yeah, they said that that with regards to the statement made in paragraph 5 the petition, that the deponent said that as per service record, the date of birth of late Prison T. Sangma was on 22 December 1959, which means his date of superannuation.
So the thing is that you have not been your pension has not been
released.
Not released. I mean, not been sanctioned, access and until now.
Nothing.
Why?
Because your lordship, he has given his date of as per service record.
Doesn't matter. It is whatever it is.
No,
admit card he gives subsequently 57.
After
so
before
he
retirement.
work for 2 years.
No, your lordship. Overstayed for 2 years in serving. No, after it was detected in March 2017 before his retirement.
Yes.
So thereafter he was asked to produce his birth.
Sit down, Vasa. Sit down. Yes, we'll come to you. Yes.
He was asked to produce his admit card. As per the admit card, your lordship, his date of birth is not there, but as per admit card, his date of birth is 1957 because he in 1974, 1st March 1974, he appeared. So thereafter, these correspondence are going on between the petitioner principal and the respondent number 2, Director of School Education and Literacy, your lordship. Even all documents were furnished to the Accountant General also.
19,
yes, your lordship.
Sorry, 15.
Yes, your lordship.
He retired 15 also, now it's 13. He retired in 17. Okay?
Yes, your lordship.
Right, so was a difficulty in rationalizing? Whatever it is
even
you calculate.
AGS, may I please your lordship, even
They
all
have
documents.
clarified, lordship. This is between the government and the AG. Actually,
And in
the
the meantime,
petitioner
he has
has nothing
produced
to do.
another birth certificate
No,
through
this is
affidavit,
not
Your
the-
Lordship.
Not another one. This is what had
Another question: if this letter, in fact, attains finality, 4 April
This
2018.
corrigendum is given at annexure 10, Your Lordship, page 23. Because there is 2 date of retirement earlier. So this is the final retirement.
Then this was determined on 23rd July 2018. Then 21 again.
Actually, as per admit card, he is retired. It should be retired on 31st 12 2015.
No.
Yes, Your Lordship. It is in paragraph, it is in page 23, annexure 10 of my affidavit, Your Lordship. Corrigendum given by the Director of School Education and Literacy, dated 4th May 2021. So because of all this correspondence, matter delayed up to 21, Your Lordship.
Yes.
Even he prayed for condemnation of his...
Lordship, we are not claiming from 2015.
No. Are you accepting this corrigendum?
We are accepting, Lordship, because
That is to be deemed to have tried in 2015.
Yes, from 2015. We have no
You
problem.
agree to that?
Yes,
You have no quarrel with that?
No quarrel, Lordship. I have asked from the petitioner, and he said whatever we do, he's not quarreling. He's not quarreling for 2000.
Okay, take down. The petitioner, who's considered to be the
assistant teacher,
wife of the deceased employee, who superannuated on which 17 on
31st 12/17 as per your...
Yes.
on
31st
March
2017.
on 31/3/2017 is before this court aggrieved with the non-release of family pension and other service benefits of the deceased employee, namely one Pripson T Sangma, PRIPSON T Stop Sangma. The only issue, as per submissions of the counsel for the parties, appears to be the uncertainty about the date of birth of the petitioner. Stop. It appears that the retirement of the petitioner in the year 2017 was on the
31st
12 2000
was on the assumption that he was born in the year 1959.
Lordship,
159. But however, on production of an admit card,
page 14.
it was revealed that where is that? His date of birth.
Admit card is at page 14.
Admit card page.
Page 14. Page
Of?
14 of my affidavit.
But on no?
Admit card dated 1st March 1974.
It was revealed that his date of birth was in fact, where is it given date of birth?
It is written 16 years. As on
Would be how much would be in the year 1959?
Yes, it should be on.
And as such, the writ petitioner had overstayed in his post by over 2 years. Next paragraph. Due to this confusion, an examination of the materials and placed on record show that there has been exchange of correspondence by the respondents with the principal party here,
AG.
Hmm?
Principal is on this affidavit on behalf of the state because
Yes, with
he was-
respondent number 4, by respondent number 4 and the accountant general, respondent number and the principal.
principal is 3. Respondent
Between respondent number 3 and number 4. Tom, no? This confusion common examination material shows that there was various communications
May I please lordship
back and
understand?
back and forth from the between the respondent number 3 and 4.
May I please, your lordship, just a minute, your lordship, because principal was not made party, but under the instruction of the 1 and 2, principal was made to sign this affidavit.
How many sign affidavits are a party also?
Because it is on record, your lordship. I have authority letter annexed with the affidavit 1 and 2 annexed here.
So respondents 1 and 2 and 4. Next paragraph. Finally, by let me correct them. A corrigitum dated. Where is it?
4th May 2020.
Where? Which page?
Page 23, Lord.
423 annexed 10.
Finally, by corrigitum dated. A shortcut the whole process.
4th May.
Corrigitum dated 4th May 2021. The date of superannuation of the writ petitioner was finally finalized as to be 31/12/2015. A copy of the corrigendum is reproduced here and below. Stop. It is further noted that as early next one after Contempt. It is also noted that as far back as on 4/4/2018, the principal of the school had clarified the date of birth and had enclosed all relevant documents with regard to the service of the deceased employee, which included copy of statement of fixation of pay, the service book, appointment order, joining report, and a copy of order of regularization dated 5/5/2000. Stop. Next paragraph. Though the information needed seemed to have been finalized by the respondents concerned, it has been submitted that the delay in releasing the service benefits or the terminal benefits was due to the dependency of the instant petition. Stop. Next paragraph. In his view of the matter and observations made above, this petition is disposed of with the direction to the respondents concerned, especially the respondent number 4, to process and dispose of the entitlements of the writ petitioner to the terminal benefits of a deceased husband within a period of 6 weeks, a date of orders presented before them.
May I please, your lordship? In the meantime, paragraph 21 may be recorded in the order, because here specification is given how much period he has worked.
Yes. Further, the statement made in paragraph 21 after an opposition of respondents 1, 2, 3 may also be taken note of in settlement of the matter, in settlement of the case. Matter stands disposed of. This is
much less, Lordship. Lordship, in this matter, I was asked to file some document. It is there in the record, Your Lordship.
Where's the mediation agreement?
I have filed it. I think it is there in the record.
Wait.
Sorry.
Who's for a petitioner?
Actually, it's for the petitioner, Lordship. Actually, for the private respondent.
Where's the mediation?
On the earlier occasion, I have filed it, Lordship. This may be in the record. I have supplied a copy of the affidavit also, Lordship.
You respond number 5.
Yes. There next annexure 2, Lordship. 2.
Oh yes. So what do you see about this?
Your Lordship, actually what happened was, Your Lordship, this Honourable Court has passed an order for the mediation, Your Lordship. But what happened was, the respondent actually, he did not comply with the order of this Honourable Court, Your Lordship, which led to the filing of the new criminal revision, Your Lordship, by the petitioner. Because the deceased did not comply with the mediation order, Your Lordship.
It's 17.
Yes, Your Lordship.
Then what happened?
And thereafter, the Honourable Court passed an order, Your Lordship. The grievance was they came by way of criminal revision because the deceased did not comply with the mediation order. And the Honourable Court passed an order dated 30/3/2020, which I have, which I want to.
It was disposed because that person, the petitioner,
He
died
himself,
at the meantime.
he was the counsel for the respondent at the time, Your Lordship.
When case is pending, he expired, Lordship.
I don't know what the case about. It's just
Lordship, it is there. Lordship.
Oh yes, yes, yes. So after the matter was closed in 30th March 2020, what happened? You went to a civil court.
Yes, Your Lordship. Actually, the matter, the sum of the property was disputed, Your Lordship, at that time. So which is still pending before the trial court, Your Lordship.
So what do you want now?
So, Lordship, at this juncture, Your Lordship, mediation, settlement of mediation, I pray that it cannot be done, Your Lordship, because some property are still in dispute, Your Lordship. So my limited prayer is just for the issuance of the death certificate, Your Lordship, to the petitioner.
Oh, you filed it recently only. It was after this order was passed to bring on record mediation. You filed actually, yes. What death certificate?
Lordship, since I am the legally wedded wife, Your Lordship.
No, but what will you do with the death certificate now?
Your Lordship.
Other claimant, there's some other wife claiming.
No, Your Lordship.
So what is the dispute?
Your Lordship, in the first place, the death certificate was issued to the second wife.
So you said there's no second wife, now you said there's a second wife.
Yes, Your Lordship. They are claiming to be the second wife, Your Lordship. But the fact is, like, I'm the legally wedded wife, Your Lordship.
No, the thing is that if it goes for a competent court, all these issues will be resolved. Have you filed a title suit with regard to the properties, which are in occupation of some properties?
No, Your Lordship. At this time, we are not, Your Lordship. Yes, Your Lordship.
And then they are occupying other properties?
No. Some of the properties, Your Lordship.
Then where, in whose possession the other properties?
It's in the possession of the son, Your Lordship. Which is also disputed, Your Lordship. The son of the petitioner, Your Lordship, which is also disputed, Your Lordship.
He's not the son.
He's a son, Your Lordship, of the petitioner, but they are having some problem.
He's not your son.
He's my son, Your Lordship, but they're having some dispute with the land, Your Lordship, regarding the.
Are you having a dispute with your own son also?
Yes, Your Lordship. So it's
very complicated. Then if we can't in the writ petition, we can't do anything.
Yes, Your Lordship. That is, but the only limited prayer, Your Lordship, just for the issuance of.
No. Where's your prayer and writ petition? I don't think someone will be.
It's in the pleading, Your Lordship.
There's no,
Because Your Lordship, earlier occasions, similarly situated persons, they have obtained the death certificate in their name, Your Lordship.
You can obtain a
No, Your Lordship, in their name, Your Lordship.
In whose name?
Similar situated, in the petitioner's name, Your Lordship. fresh death certificate, Your Lordship. Similar situated persons, Your Lordship.
Where's the case? Any authority from this court?
Yes, Your Lordship.
No, it's only for issues of a duplicate death certificate. There's no hard and
They
fast
have
rule that
obtained in their name, Your Lordship. Fresh death certificate was obtained in their name, Your Lordship. Similar situated
you
persons.
bring that on record. Do you have a copy of the order?
Yes, Your Lordship. If
Let them bring on record. I'm not aware,
right
Lordship.
now, I don't have the authority, Your Lordship.
You bring it. It's interesting because otherwise, duplicate death certificate you can get. Yes, this matter after 1 week for further hearing. Yes, you bring it.
Second call, item 9.
Resolution.
I had to let Dr. Turi air his lungs since he was insisting since he come.
I'm sorry.
I let Dr. Turi air his lungs since he had come from Guwahati. Yes. What has happened here?
Well, it's in this matter, now the Public Premises Act proceedings, are proceeding as against the petitioners,
What remains is
there is a very limited prayer, which is why, I was there before your Lordships on the last occasion. I'll just quickly take your Lordships to the prayer portion, at page 18. Because there were settlement talks, that have failed. So I'll quickly take your Lordships to page 18, Your Lordships have it, Lordships, 4 lines from the beginning. As to why a writ in the nature of mandamus is not issued, directing the respondents to forthwith refrain from carrying out any earth digging construction works in and around the suit premises of the petitioners, and further not to do anything or cause anything that to do anything that may place the life and properties of the petitioners into peril and danger till final disposal of the proceedings in respect of the suit premises under the PP Act. Now the PP Act proceedings are continuing, What I am informed is that the area where this demolition work at that point of time was going on, pursuant to orders passed by your Lordships, no work is happening at that particular area. So to that limited extent, this matter can be closed, and the PPA proceedings, we are also participating, the MTC is also following up, this matter can be closed. The other aspect, of course, is notices were issued to the private respondents because the actual work was being done by the private respondents, but they have not appeared before your Lordships, in spite of...
No, that's inconsequential now. Yes, Mr. Mr. K. Paul submits that at the time the writ petition was filed, there was a danger of the live properties of petitioners being affected in view of the construction that was being taken around the food premises. The prayer he submits at that point of time was to await the outcome of the proceedings under the private premises under PP Act, and that no action be taken by the respondents. No construction be done by respondents in the said premises. You have not submissions. You don't have any submissions to make.
But I'm not really sure what they're asking for right now. Construction work will go on as long as it does not hamper their occupation.
That's what I'm saying. That they're not doing any construction in the area which is under our.
Which hampers them. As far as I understand, construction work is still going on.
No, it's going on in other areas, not in the area which says that puts our properties in danger.
Yes, Mr. Essence, the counsel for the respondents, I have no submissions to make, except that the proceedings are underway, and that any construction be done shall not hamper the operation of the petitioners.
The occupation of the
occupation of the petitioners.
I'm said of the occupation of the petitioners. In which submissions, nothing remains for consideration. The matter stands closed. Yes. What is? You all were here. You have to come running all the way.
It's become like a football game, from one goal post to the other.
Yes.
Obliged.